We're going to turn this over now to Tina and David. They're going to be doing a great presentation called Who's Zooming Zoom, or Who's Zooming Who. And also, I'll ask everyone if you could please, just for the, I guess, the experience today, if you could switch over to the speaker view. I think that's going to be beneficial for everybody. All right, please go ahead, Tina.
All right, well, hello everyone. First, just a couple of Zoom housekeeping items. We ask that everyone who's not participating to please stay on mute. And for those of you that are participating, please stay on mute until it's your time to speak. Also, if you are participating, please make sure your video is on. I understand Sheila got a pass for that, but otherwise, if you're participating, please make sure your video is on. If you are not participating in the presentation, then please turn off your video. So we started our session today listening to Who's Zoomin' Who, a song by Aretha Franklin. Some of you are probably bothered by the grammatical error and would have preferred Aretha call the song Who's Zooming Whom. I am told Larry Nodine is a likely suspect in this category, but the rest of you probably thought, what is a song that Aretha Franklin was probably embarrassed to have recorded in 1985 got to do with ethics and IP? Well, the honest answer is not a whole lot. The challenge is we got to Zoom tonight and we got to learn some ethics related to IP. If the song manages to plant an earworm with some of you or brings back some fond memories from 1985, be sure and play along with our presentation tonight of Who's Zoomin' Who, or Whom. Here's how it will work. So we'll provide pictures from 1985 of various November pupillage group members. And here we've got some examples. So we've got Preston Hurd sporting a sailor suit in 1985, and then a more recent picture of Preston sporting a lawyer's suit. We were unfortunately not able to find Preston in a recent picture sporting a sailor suit. We also have Suzanne Werner from 1985 in a very comfortable onesie before she became litigation counsel at Coca-Cola. We have pictures of Mike Hobbs from 1985 and today, proving he has the same haircut and that he's happier as an adult than as an adolescent. Finally, we have a picture of Tim Holbrook, although it's hard to see in the picture from 1985. Some have claimed that he darkened the picture so you can't see his flowing mullet. But it's easier to see that he was happier as a young guy with a mullet in a gray tuxedo than he is as an adult. Now we have pictures from 1985 dispersed throughout, and we will include polling questions for you to identify who's Zoomin' who. With that, let's get started with an hour of IP ethics.
All right, Zoomers, let's get this last class over with. We've got several cases implicating ethical issues that we need to get through today, and I'll be calling on you randomly as usual. And so you have to tell us what you know about the case. Let me start off with Ms. Senatempo. Let's talk about this Gilead Science versus Merck case from the Federal Circuit in 2018.
Well, what happened was this lawyer was representing a client subject to a non-disclosure agreement, an NDA. The lawyer was on a call with the other side of that NDA, and someone on the other side disclosed some information about their commercial product. The lawyer took that information and used it to narrow the claims of a pending application so it covered the commercial product. Then he got that patent issued with the narrowed claims.
So the patent had support for the narrower claims, But the reason the lawyer narrowed the claims was because of the information the other side disclosed, which was subject to this NDA.
Exactly.
Okay, so then what happened next?
I turned the page. Well, the patentee sued and won 200 million, but then the Federal Circuit held that the patent was unenforceable against this defendant, not against all defendants, based on unclean hands because the lawyer misused the information from the accused infringer to narrow the claims. The claims were valid, not derived, and they had support, but the patent was not enforceable against this one defendant.
Well, good job, Ms. Sematempo. So let me ask Ms. Garbler, what are the lessons from that case for practitioners who receive information subject to NDAs? What advice would you have for counsel whose clients disclose confidential information to a competitor, even if they've got an NDA in place?
Well, my name is pronounced Garber, but Professor Hricik, I am not sure I can answer your questions. I didn't do the reading because I have been distracted by the election news and the runoffs here in Georgia.
Yeah, well, haven't we all? Well, how about you, Ms. Holt? What are the lessons from that case for practitioners who receive information subject to in an NDA?
Well, if you're the recipient, don't use information disclosed under a confidentiality agreement in violation of that agreement.
That is brilliant. But don't you think that the Gilead case has broader implications? What if during litigation there was a prosecution bar? Well, first of all, what is a prosecution bar? Is that a place in Alexandria where patent lawyers used to go before the pandemic?
Unfortunately, I think that's a library, Professor. But back to your question. I think a prosecution bar is usually part of a protective order. The general rule is that a protective order stating that information disclosed during discovery can't be used by the recipient for any purpose other than the litigation is enough to protect the disclosing party. But sometimes there's such a great potential for even inadvertent misuse that the court will enter a protective order that basically says that certain people are barred from even seeing the information.
Can you give me a concrete example of that, Ms. Holt?
So if the lawyer for Microsoft is prosecuting patent applications for Microsoft, that lawyer may be barred from seeing information disclosed by the opposing party in litigation with Apple, for example, where the information Apple will be disclosing could be used during prosecution of the applications the lawyer is prosecuting for Microsoft.
So very, very good. So how could the same Gilead type problem come up in that context if the lawyer for Microsoft isn't even supposed to see the information from Apple?
I guess through inadvertent conversations or even deliberate breach. The courts say it isn't good enough if a lawyer prosecuting patent applications for Microsoft promises not to misuse the information from Apple. Instead, because the risk of subconscious misuse is so great, the Microsoft lawyer prosecuting the applications for Microsoft is barred from seeing the information Apple discloses in discovery at all.
Right. Gilead seemed to involve someone intentionally misusing information in violation of a confidentiality agreement. But the problem could come up in many ways, including that way that you described. So Ms. Tempacento, in light of what Ms. Holt added to the conversation, what should lawyers do when they're in litigation and there are prosecution bars? Ms. Patento, are you there? Are you on mute?
Oh, sorry, I was on mute. My name is actually Senna. Oh, never mind. I think you asked what should lawyers do when they're in litigation where there are prosecution bars. I guess they should watch for violations by the other side.
Well, yeah, but that's often going to be hard to detect, right? I mean, in Gilead, it's not like the misuse came to light right away. The claims were narrowed, prosecution continued, the patent issued, then there was a lawsuit, and then it came to light during discovery. That was probably years later.
Yeah, I think this shows that a big ethical lesson from Gilead is that our system requires diligence and monitoring, but it also takes a lot of trust by lawyers that both sides will follow these orders and agreements.
It does. I mean, it really does. And so what about the people not on the other side of the information exchange, but on the lawyer's side. What should lawyers do to ensure that their own people don't inadvertently or accidentally violate a prosecution bar or similar kind of agreement?
I guess they should remind people on their side how important these agreements are and of the consequences.
Right, and then who are these people?
I remember reading that lawyers need to think about not just the lawyers in their firm, but in-house counsel, business people, experts, and other folks.
All right, this brings us to our first Who's Zooming Who polling question. Everyone look at the picture and pick the person you think it is from about 1985, and take a moment to admire the matching jogging outfit and backpack. Is it Colin Wright? Is it Lisa? Is it Sheila? Is it Jason? Or none of the above? You can put your answers in the poll. Okay, I believe everybody has maybe entered their polling. So the correct answer is Jason Greer. So the next Who's Zooming Home question is, who is the dapper looking guy in the tux from 1985? Is it John DeRico, Tim Holbrook, Colin Wright, Scott Boone, or none of the above?
Hold on. I gotta get down to the picture. And Kobe, I think you're on mute.
Sorry about that. Is it John DeRico, Tim Holbrook, Colin Wright, Scott Boone, or none of the above? So you can put your answer in the polling. Okay, so the correct answer is Colin Wright. That was our first round of Who's Zooming Whom from the November Pupils Group. Let's get back to the ethics.
All right, so let's have someone tell us about this next Federal Circuit case on client identity. This case is Trimble Inc. versus Per Diem Company. Ms. Parker, now there's a name I can pronounce. Why don't you tell us about the Trimble case? What was the Trimble case about?
Oh crap, I don't even remember that case existed. Oh crap, I thought I was on mute. I'm sorry, I don't remember that particular case or any of the details about it. Something to do with Seth Trimble, maybe?
Not good, Ms. Parker, not good. Let's see here, Mr. Hobblebrook, how about you?
It's Holbrook. I am prepared. I am always prepared. In fact, I happen to have an illustration for this case. Now here is the chart of a corporate organization for Cigna that I found on the internet. Suppose you're an associate in a big fancy Atlanta law firm and you're hoping to make partner. Someone from a potential new client asks you to bring a huge trademark infringement suit against Cigna Behavioral Health Inc. It is circled in red on the left. But when you run a conflict check, you learn that a partner at your firm represents B Life Services Inc. See it way over there on the bottom right, circled in red. What would you have to know if you could take on the big trademark case against Cigna Behavioral Health when a partner represents B Life Services? That's basically what the Federal Circuit addressed in the Trimble v. Per Diem Company case.
Well,
aren't you annoyingly prepared? Don't we need to know whether the partner's representation of ViLife is related to the adverse trademark suit?
Nope, that's the former client rule. You can be adverse to a former client so long as the adverse matter isn't substantially related to the representation of the former client. But the rule about current clients is that no lawyer can be adverse to a current client of any other lawyer in that firm.
Well, maybe you are overcomplicating this. The partner represents ViLife, and you want to sue Cigna Behavioral Health, Inc. Of course, Cigna Behavioral Health is not the client. Seems simple to me.
Well, maybe you are oversimplifying it. The Federal Circuit joined sort of a majority approach on this and said that the answer as to who and not whom your client is turns on a number of factors. For example, whether there is overlap in personnel between the two companies, whether they share infrastructure, whether they share some of the same officers, directors, management, whether they share the same legal department, whether they share the same substantial number of corporate services, whether they share common infrastructure like computer networks, email, internet, health benefits, letterhead, so on and so on.
So to know whether you can take on this trademark suit against Cigna Behavioral Health, Inc., you have to know how their phone system works? Are you kidding?
I'm not kidding. I never kid. But phone systems, healthcare benefits, all sorts of things can be considered.
Okay, so Mr. Holybrook, what can lawyers do to avoid uncertainty over who is the client?
It's Holbrook. Anyway, lawyers can use a good engagement letter. Specifically, lawyers can use engagement letters to say that by representing one company, they don't represent the whole corporate family. In fact, if I can share my screen, I prepared samples to hand out to everyone.
Yeah, that won't be necessary.
No, wait, Professor Hricik. Don't clients use outside counsel guidelines and annoying stuff like that to say if you represent one party of a company, you represent it all?
Yeah, and that's often how these disputes over who is the client ends up. The law firm's engagement letter says that the firm only represents the one company, and the company's outside counsel guidelines say the firm represents every single part of it.
That sounds like the classic battle of the forms from contracts.
Oh, give me a break. That is so stupid. Of course, Holbrook would think that makes sense. Typical gunner move. Crap. Going on mute.
Yeah. Mr. Kent, who do you think wins that battle of the forms?
Well, I'm betting on the clients, as usual.
Yep, that's usually the answer.
Okay, so time for our second polling question to determine who's zooming whom. Please look at the picture from 1985. Who is the happy 2-year-old from 1985? Is that Russ Dunlap, Art Gardner, Keith Broyles, Eric Maurer, or none of the above? Please input your answers. Okay, this is actually Russ Dunlap, shown here as a 30-something-year-old lawyer. Okay. Now let's turn to our most disturbing photo. So in this example, which of the following is shown in this photo? This is Art Gardner, David Hricik, Judy Jared Black, or Lou Isoff, or none of the above? Look at it closely. That's actually David Hricik in the upper right of the photo, but I'm not going to go back and show you. We need to move on for several reasons. Let's see what the class has for us next.
Yeah, the story behind that photo. All right, we got one more case for one more time. And Ms. Gentes, tell us what you know about this Davis case.
Davis, what are we even talking about?
All right, well, let's move on to Ms. Jerkiecki Black.
That's Cherokee Black. And I know everything about this one. First, Davis isn't actually a case. It's a decision on a petition from the USPTO. And what happened in the Davis matter is that a guy filed an application, but he didn't name an inventor. Instead, he made it clear that the claimed invention was a creativity machine called Davis. The examiner issued a notice of missing parts. The applicant stated that he didn't invent it. The machine did through artificial intelligence. Eventually, the USPTO issued a decision and published it, stating that only people can be inventors and not machines.
Wait a minute, a machine? Is that like a voting machine? Because that could be a fraudulent invention. Did you see that event at the Four Seasons?
Look, let's stay focused. Ms. Black, so does the guy list himself as an inventor even if he didn't invent it?
Well, it's Cherokee Black. But no, the USPTO said that someone cannot be named as an inventor if they don't meet the statutory definition of an inventor, conception, and all that stuff.
So no one is an inventor.
I demand an inventorship recount.
I'm ignoring that. I think, Professor, you asked whether there is an inventor. That application hasn't gone further, but there are some USPTO statements in an October 2020 publication that suggest that there could be people who were involved enough under normal inventorship law to be inventors.
Wait a minute. What about foreign offices? Are they taking a different approach?
Not so far. The UK IPO and the EPO reached the same results as the USPTO.
But I heard that the USPTO's October 2020 petition, publication says something about all of this. Does it say anything different than this petition?
Not really. It basically said that because of the statutory language, machines cannot be inventors. It said that most people thought that human beings would be involved enough in the process of using AI that for a while, at least, a human would qualify as an inventor.
We should take that up with the highest court in the land.
Back to the real question. Which people are inventors when AI is involved? The people who determine the data set? Who writes the algorithm? The people who write the algorithm?
Well, we just don't know yet. We use the same inventorship law as always and do our best.
But what about obviousness? The test is whether a person of ordinary skill in the art who knew the prior art would have come up with the invention. So if AI invents something based on examining prior art, doesn't that mean it would have been obvious to someone who knew it?
State law should control, especially Georgia law. All eyes are on Georgia.
Well, as for obviousness, a machine isn't a person of ordinary skill. So the fact that a machine found it obvious doesn't mean a person would have, I guess.
Well, what about if AI creates an original work of authorship? Who owns the copyright?
In that October 2020 PTO statement, the USPTO said no. Think about the monkey selfie case. Only people can create works subject to copyright.
What if AI creates a not so original work that infringes a human being's copyright held by another?
The USPTO said that AI can't infringe, but someone might have been involved enough to directly or contributorily infringe the copyright held by another.
Oh my God, the plague is back. It's widespread fraud. Take to Twitter. Let's rally the militias.
No, all right. this seems like a good place to stop and think about where we are. It is 2020. But somebody said earlier, somebody said something earlier, and I think it's important to remember we have ethical rules and they are great, but they are just rules. What our system requires is honesty and trust. We have to be able to trust in each other, or this system simply does not work. The world doesn't work, and the IP world is no exception.
Yes, exactly. Trust, but verify.
And now, everyone, time for our third Who's Zooming Whom, or whom, or who, or whatever. Please take a look at this picture. This is a 1985 party girl.
Whoops.
Well, so it is Tina. Everybody knows that it's Jackie Hutter. But Roxanne, Tina, and Katrina want you to know they could have been party girls too.
I got some votes.
So next photo.
Hold on.
This shows a number of 1980s brands. If you look closely, you will see a Care Bear, a Pound Puppy, a My Little Pony bed tent, a Pac-Man sleeping bag. Who do you see around that's surrounded by these relics from 1985? Is it Tara Sharp? Is it Alex Holt, Ryan Gentes, Stephanie Clausen, or Sheila Garber? Okay, it is Sheila Garber, who was obviously destined to become an IP attorney. And that is our final session of Who's Zooming Whom, or Who from the November Pupillage Group. Let's turn on to an open discussion on ethics right now.
Okay. Aside from the difficulty I'm having moving the slides back and forth, that was a good job. Thanks to everybody on the group. So now we're going to open up to a few questions. And I think that
Let me start. Can I start off with that one that someone raised up in our group?
Sure.
What if, in in the thing Tim was talking about, you are that young associate and you're trying to figure out if you can bring in this new client, and Mr. Big Shot corner office partner has the existing client who you may or may not be averse to depending on who the client is. I mean, I know what the rules are, and Tim explained them real well, but as a practical matter, as a lawyer, a baby lawyer, a young associate in those circumstances, how do you deal with that problem? Anyone have any thoughts about that? I'll call on people. Come on, you guys have been there. You want to bring in a new client and the corner office partner is going to sit on you if you do it. How do you bring up that discussion in a way that won't end in an unhappy place?
Well, one option is to call your friendly neighborhood boutique law firm and talk about moving your practice. But that's just avoiding the issue, I suppose.
there's also a hotline that the Georgia Bar has, the ethics hotline. If you have questions, you can always call and ask them so that you're armed with the right answer when you go in to talk to the partner.
I also think after you have that conversation with the partner, maybe you should ask your client. Some clients are very prickly about conflicts, but some are very reasonable. And so getting to your client sooner rather than later, giving them time to consider and maybe, working through what a waiver might look like is always an option.
Yeah, but now I'm gonna get practical though on you. So I say to this potential client, I understand you got a trademark suit against whoever it was, Levy or whatever they're called. Is it okay, in order to get, I got to get consent from my existing client. Can I go tell my existing client that you're about to sue them for trademark infringement? What are they going to say if you ask them that?
No, that one won't work.
Yeah, and so I mean, and if you go to that partner and you say, Mr. Partner, I'm thinking about suing. I have a potential new client, and they're going to be adverse to this affiliate that's 9 tiers away. That partner, if they have a relationship, is going to say, hell no, I don't care if they don't have the same phone system and health benefits. So how do you bring in business if you're in a large law firm, I guess is where this is going to happen a lot, and you've got this kind of conflict that can come up all the time if you're a young lawyer. How do you thrive in that atmosphere, and how do you deal with those difficult conversations if you're trying to bring in business? No one's biting that hook? Okay. Go take it somewhere else, Keith.
Okay, so another question that came up during our discussion had to do with when lawyers change firms. So David, can you walk us through some of the issues with how conflicts move with a lawyer?
Yeah, and there's a horror story case, and y'all will like it because it involved a patent troll that got disqualified. But so here's the weird thing that people don't watch for very much. Suppose I'm working at Coke and I'm gonna go move in-house to Pepsi. All right, and I know that's never gonna happen. But the rules are that when I move jobs, so I leave Coke and I go to Pepsi, I still am disqualified from anything I was personally involved in. So as Tim said, once I leave, when a representation is over, I can be adverse to my former client, just not in a substantially related matter. So I personally go over to Pepsi. I can't be adverse to Coke in anything that's related to what I did while I was over there at Coca-Cola. Now, here's the way the rules work, though, is once I go over to Pepsi, everybody at Pepsi's in-house legal department is also disqualified to the same extent I am, unless they screen me off from something. So in this case, it's called Schlumberger versus Geo3D or something like that. A lawyer went from Schlumberger to Acacia, and they didn't set up a screen right away. And it ended up that Acacia lost all of its in-house legal department, and it even lost its outside counsel when she transferred. Now, y'all are saying, Acacia, who cares? I've been involved in matters where it's not Coke and Pepsi, but it's companies like that. And the lawyer, think about this for a second. Okay, I leave one place and I show up at the other. When did a matter begin when I was at Coke, when we're talking about a patent, for example? Did it begin when the invention disclosure statement came to me? Did it begin when the application was filed? What if there was a customer number that we used in the office, and I happened to have my name on that customer number, but I didn't have anything to do with the actual patent application? In pharmaceutical areas, what if I was involved in something to development of the drug, but not anything about the patent? Was I involved in that matter? And then when I go over here, I can't talk about the exact facts of the case, but imagine I'm now at my new firm, and I signed some stupid piece of paper agreeing to something in that case, and it's related to my old firm. Everybody can arguably be instantly disqualified, and the company loses its entire legal department. So those are just some of the issues that can come up. And of course, you can get arguments that people misuse trade secrets and all that sort of thing. So it can be a real quagmire. And in competitor changes, you don't get a lot of people saying, as you were saying, oh, I can deal with that conflict here, let me sign the form. Especially if there's a lawsuit pending, they're going to be like, I got an advantage now. I'm going to make Pepsi lose its entire legal department and maybe kill their outside counsel at the same time because they hired a lawyer from our firm.
So David, seems to me you learn in law school in the ethics course that waivers don't work in Georgia. But we all talk about waivers, and you were talking about going down to the corner office. You're going to hear that lawyer talk about waivers. So talk to us about how waivers can be used under the Georgia rules.
Well, very carefully, I guess, is the short answer to that. The rules require informed consent after full disclosure. And so you'd have to explain to each affected client, so Pepsi and Coke in my scenario, because I have a former client who has to give consent if I'm going to be adverse to them, and also my new firm or my new company, Pepsi. I have to explain to each one of them, and you don't have to technically do it in writing, but you're an idiot if you don't, the pros and cons of what we're proposing to do. So, for example, we might say that I'm going to be over here and I might be involved in a matter adverse to my former company, but I won't be involved in patent prosecution. I won't be involved in patent acquisition, drawing lines around it. It's really difficult to get consent, especially if you don't do it in writing, because what will happen later is something will go wrong. And either your old client will say, you did something outside the boundaries of what I agreed to, so I'm going to sue you or report you to the bar. Or the new client, something will go south and they'll say, you held back in a way that I didn't understand. I never would have agreed to this if you had told me you weren't going to be as zealous as you were. So it's really, really difficult to do it appropriately. Not impossible, and I know you all have done these things, and there's a lot of times where they fly through without a problem. But if you do not do it right and something blows up, it can, unless it's done properly, it will not be a good defense against a disqualification or even a malpractice suit in some cases.
So does an ethical wall solve all the problems?
Yeah, yes, in some circumstances. The issue I always see people raise up is, what does that mean nowadays? And I'll give you a simple example. So I change over from Coke to Pepsi. And now I'm on the email list at Pepsi, and everybody is always sending around emails about that case that I'm not supposed to be involved in. I'm screened off and I'm walled off. And I just on this email list. And so every day I don't read them, I don't do anything about them, I don't care about them, but I'm getting that information. Somebody later on can argue that was a violation of the screen. How do you deal with, and there are ways, but how do you deal with information that this disqualified lawyer is not supposed to have access to activities? And again, the one case I was involved in recently, the lawyer, when they changed jobs, did the most innocent thing. I mean, I can't think of something other than what they did, but it would be like, signing off on a set of requests for production that were sent over where somebody else wrote them, you just sign your name on them. It was something that did not matter at all. It was a ministerial act. And that turned into an effort that failed to try to cause that company to lose all of its in-house counsel. And they tried for the outside counsel as well in a huge matter that really, really would have hurt that client. So screens, they're great when you're in the abstract, but actually when the rubber hits the road, sometimes it can be very, very hard to implement them. And the other side of it is, I leave my old firm and I go to this new place, right? And they say, my old company says, we'll let you do that as long as there's a screen in place, and you can't do this, you can't do that, you can't do the other thing. Well, now how much value add am I bringing to my new company? And I have seen this happen with lawyers where they get to the new place and they have to agree to such constraints on their practice that it hamstrings their ability to represent their client. They got to leave the office, not the office, the room, which I guess now doesn't happen that often, but they have to leave the Zoom meeting when certain topics come up. And that all has to be documented, or they get in trouble with having violated a screen or a waiver that was given before they left.
So while other people are thinking about questions they want to ask, I want to just call out the 1985 pupillage group members on this slide. Dan Kent with hair, Roxanne Senatempo with big hair, Stacy Frederick with very little hair, and me with very dark hair. We had a couple of people, or probably more than just these two, on our pupillage group that really it was too soon to call because they're so very young. So I'll pause and see if other people have ethics questions they want to discuss, or just make sure we flesh out a little bit.
Someone said Anne had her hand up. Ann Ford, did you have your hand up?
I did, but I took it down.
You have no idea. This is exactly like the real Zoom. And by the way, this is how I do it, so you can't see me and I'm in the dark. You call on people and they don't know what you're doing. Nobody will answer. This feels like I am doing what I did for 3 hours today. You all haven't changed since law school. Maybe
Well, David, this may not be an ethics question, but I do think you owe us an explanation of that photograph of you and how that came about. You said there was a story. You can't leave it hanging there.
Okay, this is how this happened. I had hair. You got to start off. I realize this, to many of you, that's an unbelievable hypothetical. So my hairdresser calls me up and she says, would you do a photo shoot? She's got something going on. And I'm like, sure. And so, hey, I had a hairdresser. That's, God, those were the days. So I show up and I think all they're going to do is like cut my hair and take my picture. So there's 3 of us there. I didn't know who those other 2 people were. And they, do it. And then they say, okay, we got to go somewhere in a car. We go somewhere in a car and there's a big professional photo thing, with those lights and all that stuff. And there's a gym. And the guy tells me you got to work out and pump up. And I'm like, what? Because I'm thinking, and this is for a calendar. By the way, my picture's on a calendar in Chicago. So I lift weights for a little while, and then they take the pictures of us, and the girls kind of got some stuff going on. There's another picture where she's got her high heel above my head. I'm not sure what that was about. And I'm on a calendar in Chicago. Many of you admire me for very little, but I bet you'll admire me for that. So that's the backstory behind that stupid picture.
And thanks so much for asking, Dan. So one more question. Anybody else have any ethics questions for David to talk about, or anybody else to opine on? Well, then we'll end with a public service announcement. Lisa Moore from 1985 reminds you of the December 1 local runoffs, which includes the runoff for John Lewis's remaining term. And also Crystal Gentleman from 1985 reminds you of the January 5th Senate runoffs. And that's all we have today.